The premise. An employee hurts his back lifting a box. Simple. You have a workers' compensation claim, right? One claim, one statute, one adjuster who's already annoyed. He's out for 9 weeks. The twist. Then the doctor releases him with restrictions. He turns 58. He asks for a stool. The danger. And now you don't just have a workers' compensation claim. You have 4 claims. And 3 of them come with their own little acronym of their own. Welcome to Beyond the Handbook, where we take "it's only a comp claim" and explain why siloing claims into individual buckets is the wrong way to do things. I'm Chris Scott. This podcast is brought to you by Thomas and Hafer LLP. It's for informational and educational purposes only and is not legal advice. Listening does not create attorney-client relationships. Laws vary by jurisdiction and change frequently. Please consult qualified counsel for advice specific to your situation. This is part 1 of 3. If you leave after this episode, you will know exactly enough to be dangerous, which is the worst possible amount. Hello and welcome. Today kicks off a 3-part series on what happens when Pennsylvania workers' compensation collides with the various disability statutes. Part 1 today is the map. Part 2, which will happen in the next few weeks, will be a deep dive into the ADEA. And we'll follow that up with Part 3, the FMLA. 3 episodes altogether, because doing all of this in one would require a runtime measured in hours, not minutes. Here's the setup. Workers' compensation obviously is a closed system in Pennsylvania. It was designed in 1915 as a great bargain. The employees gave up the right to sue for pain and suffering, and the employer gave up the right to argue about fault. Everyone gets a little bit of certainty, nobody gets rich, and the whole thing runs on forms that have numbers instead of names. That system worked beautifully for about 75 years, up until Congress showed up and changed things. Because starting in 1990, the federal government layered a completely different set of rules on top. All of those rules are impactful on injured workers. The ADA, the FMLA, the ADEA, GINA, and USERRA, as well as here in Pennsylvania, the Pennsylvania Human Relations Act, which is the ADA's older cousin, who shows up with all the same parties and has its own rules about how long you have to file. The worst part is that none of these statutes talk to each other. They don't share definitions. They don't share deadlines. They don't even know what disability means. They just share the employee. That's the whole series in the one sentence. One human being, 4 statutes. Every one of them thinks that it is in charge. That's why we've made this into a 3-part miniseries. Let's start with the mistake I see most often, and I see it from a lot of really good lawyers. The exclusivity provision. Comp is the employee's exclusive remedy against the employer for a work injury. Every comp practitioner reads that and hears "we're covered." You're covered for the injury, and that's the whole sentence. What exclusivity means is that it bars tort claims for physical harm. It doesn't bar a claim that you failed to accommodate from the restrictions. It doesn't bar a claim that you fired someone for taking protective leave that results out of a work injury. It doesn't bar a claim that you looked at a 58-year-old with a shoulder tear and decided he was quote-unquote expendable and probably ready to retire anyway. The last one is an ADEA claim wearing a comp file as a disguise, and that disguise comes off during the depositions. Think about it this way. Exclusivity protects you from being sued over what happened to the employee's back by way of injury. It doesn't protect you, the employer, from being sued over what you did about the employee's back injury. 2 separate events, 2 different rule books, and the second one is unfortunately where the real money lives. because here's the part that should get your attention. Comp exposure is somewhat capped. I know a lot of people out there will say, well, there's no caps on the amount of damages that could be paid to someone for the remainder of their lifetime. However, the majority of comp cases are at least calculable. You can put a number on it. Disability discrimination, however, comes with compensatory damages, potential punitive damages, and the other side's attorney's fees, and that can be a real tricky problem. The two systems are essentially looking at each other and watching and waiting. Everything you file, every job offer letter, every surveillance decision, all of it potentially is discoverable in the other case. Your comp file is not a vault. It potentially is an exhibit. Here's where the wheels come off, the vocabulary section. The word disability appears in all of these statutes. It means something different in each and every one of them. It's the most expensive vocabulary problem in the American employment law. In workers' compensation, disability means loss of earning power. That's it. It's an economic concept. An injured worker could be missing a finger, but if they're back to work at full pay, there's no disability. Disability in our world is an average weekly wage and compensation rate listed on a notice of compensation payable. In the ADEA world, disability means a physical or mental impairment that substantially limits a major life activity. That's a functional concept. It has nothing to do with wages. And after the 2008 amendments to the ADEA, the definition is broad enough to cover most of what panel physicians are already writing down. Most of you listening out there in podcast land probably have a disability that needs to be accommodated by an employer. In the FMLA, the magic words are not disability at all. The phrase in this area is serious health condition, which is a different test on a different form with a different clock. Under the ADEA, disability does not matter even a little bit. What matters is the assumptions people make out loud or in written form as older workers get hurt. Here's the trap. An employee can be disabled for the purposes of the ADA, but not at all disabled for the purposes of workers' compensation. Additionally, an employee can be back at full duty with zero comp exposure and still have an active FMLA entitlement and an accommodation obligation running quietly in the background. 4 statutes, 4 definitions, same employee, and he still wants to know about that stool he's asked for. All right, let's go into the moment this actually explodes. It's a document. You've seen it 100 times. The release with restrictions. The treater or the IME doctor signs off, capable of modified duty. No lifting over 20 pounds. No overhead work. Sit or stand as needed. In the comp file, that's a good day. This piece of paper is a foundation of a modified duty job offer. A notice of ability to return to work goes out. Maybe the person goes back to work. Maybe there's litigation, but at least we're moving forward. In the ADA world, the same piece of paper is a notice. Notice that the employee has restrictions. Now comes the problem. That notice starts an interactive process. Whether or not anyone in the room has ever used that phrase, it still has to happen. Those two instincts pull in opposite directions at times. The comp instinct is to put together an offer that's technically within the restrictions and see what the claimant does with it. If he refuses in bad faith, benefits can stop after litigation. That's a legitimate strategy, and I'm not talking anyone out of it. But the ADA instinct is to have a conversation first, individualized, documented, and actually about the person itself. Those instincts are not necessarily in conflict so long as you run them in the right order. The interactive process contained within the ADA makes your modified duty offer stronger because it makes the offer look like what it's supposed to be, which is a real job for a real person instead of something invented in a conference room to create a defense. The employer who documents the conversation tends to win cases. The employer who skips it sometimes would win on the comp case, but loses on the ADA case by a considerable amount. All right, so what do we do? There's 3 things that we can do. 1, Every time a work injury keeps someone out for more than a few days, ask out loud whether the FMLA clock should be running. In my instinct, it always should be. And always, always, always designate it in writing. The FMLA leave runs concurrently with comp leave, but only if you say so, and only if you let the injured worker know. If you skip the designation, you've handed an employee an additional 12 weeks of leave for free. And you did it by doing nothing, which is an unfortunate way to lose. Number 2, when restrictions show up, treat them as a comp event and an ADEA event on the same day. 1 document, 2 calendars. 3, keep the medical separate. Comp files are stuffed with medical records, and the ADEA has confidentiality rules that don't care how you came by them. The supervisor does not need the IME report. Nobody needs a copy of anything in a group chat. And as a bonus, never say the words, "He can't come back until he's 100%. Those 6 words have unfortunately lost more cases than any other sentence in American business. It's the workplace version of saying, "Hey, what could go wrong?" So that's the start. That's the map. Comp is one system. Disability statutes are a completely different animal. They land on the same employee at the same time. And that overlap is where the exposure lives. In the next episode, we'll go and do that deep dive on the ADA. What counts as a disability when the injury came from work? Why full duty or nothing is potentially the most expensive policy in your handbook. When a modified job duty quietly turns into a permanent accommodation obligation. And what happens to your comp defense when the accommodation conversation goes sideways, as it does sometimes. Part 3, the FMLA. Concurrent designation, light duty problems, supervisor liability, and the overlap, that 12-week cliff. And why, while he was out on comp, isn't a defense to an interference claim. Until then, I'm Chris Scott. This has been Beyond the Handbook, where policy ends and the real work begins. Go get that man a stool.